Just note that this matter is scheduled for a jury trial that is currently set for April 1st through May 31st of this year in Ada County.
I'm so glad that there's cameras in the courtroom, but the cameras aren't TV quality resolution, that's for sure. It's still hard to see, but it's better than nothing. Let's do a real quick recap of who Chad Daybell is. He and his wife, Lori Vallow, were charged with murdering Lori's 2 children and Chad's wife. Lori has already been found guilty, and she's now in Arizona getting ready to face charges for murdering her 4th husband. Her court case could possibly run simultaneously with Chad's court case in Idaho. Okay, let's go back to our boy Chad and see what happened in his hearing. There's quite a few things that we've been wondering for about 3 years, how things would go, and now we finally have some answers.
The court's scheduling order has listed out other deadlines coming up, and I've discussed that with counsel.
One thing that has happened over and over with every hearing that Chad has been in, he shows very little emotion, which is, I'm sure, he's trained up to do by his attorney, John Pryor. But later on in this one, he actually has some reaction, and that was surprising. You'll see that in a minute.
In general terms, then, noting the dates of the trial, there were a few matters the court wanted to raise, and then I'll get to counsel specifically with any questions or concerns you have about trial. Let me go back to this questionnaire then. The court does intend to and will be distributing a jury questionnaire to start the voir dire process before we begin evidence in the trial. The questionnaire has been now approved in its contents by counsel based on our hearing yesterday. The only remaining alterations will be the completion of the witness list that would be included in the questionnaire, and I will have a final version to be approved by counsel before it's printed off and distributed to potential jurors in Ada County.
This is something we've been wondering if Chad's case would be in Ada County like Lori's was. We always assumed it would, and in fact it will be, which means Boise. Quite a distance from where the crimes took place, so they could get a larger jury pool of people who don't know Chad.
So knowing that we'll still have that final last look with the witness list completed with that. And is it you, Ms. Blake, today for the state?
Yes, Your Honor.
All right. Do you have any other questions or concerns on the questionnaire other than what we discussed yesterday and what I mentioned here this morning?
No, Your Honor. The state has no other concerns.
All right. Thank you, Mr. Pryor. On behalf of Mr. Daybell, anything further to add on that questionnaire?
No, court judge, and as I previously noted to the court, my list of witnesses was provided to your staff, I believe, on either Friday or Saturday evening. So I think I've complied with the court's directive regarding this disclosure of witnesses.
All right. Thank you, counsel. The next topic I guess I'll bring up then, as it does relate to witnesses at trial. The court's entered an order that the trial will be live streamed on the court's channel. The concern that I have there, and would need counsel to instruct carefully any witnesses, there will be an order for exclusion of witnesses, I presume, entered in this case, and that relates to witnesses not observing testimony before they testify. I guess 2 points to bring up there. Number one, if there are victims attending the trial, we had this issue come up and made some decisions on that in the prior case where Lori Vallow's trial went through, and who was permitted to remain in court under the victim statute if they were in fact a witness and who was not. So if counsel could just keep that in mind. And then secondly, with it being live streamed, certainly that gives anyone an opportunity to be observing and watching the trial before they testify. And so the court is going to be requiring a witness to testify under oath that they've not been observing trial proceedings before they testify. Otherwise, if I find they violated the exclusionary order, then they may not be permitted to testify. So Ms. Blake, then on behalf of the state, if you would just keep that in mind in terms of who's going to be in attending trial that may be a victim and witness, in addition to making sure you instruct any potential witnesses that they're not permitted to observe the proceedings on the live stream or in any other way before their testimony. Then we'll try to avoid that situation coming up at trial.
Your Honor, I think we're finalizing any list of people that intend to attend the trial in person. In anticipation of an exclusionary rule, the state has sent out a letter with our subpoenas, which we always send out. We did add a section regarding the exclusionary rule, advising the witnesses that we believed it would be this court's intention to put that into place, that they would be questioned about it, and that they should not be watching or observing any trial unless otherwise permitted by the court, so such as the victims.
All right. Thanks for the representation there, Ms. Blake. Mr. Pryor, any concerns or questions on, and at this point, I guess it is just my intention to have an exclusionary order entered. I'll ask if there is going to be any objection to that. Mr. Pryor, do you agree that would be appropriate to enter in the case?
Judge, I think that is appropriate, and I anticipated the court was going to do that based on the Vallow trial. I included actually in my actual subpoenas, Judge, language that directed every witness that has been subpoenaed not to discuss or review the case and look at the trial. It's included as a part of the subpoena that was issued. So if the court looks at some of the subpoenas I'd issued, you will note that there's a section on every one of my subpoenas that talks about the fact that they are not to observe the trial proceedings under any circumstances. So law enforcement officers, all of those folks have been directed to do that. My only concern, Judge, is that many of my witnesses are going to be witnesses that need to be subpoenaed and aren't necessarily would show up voluntarily. So I'm concerned that they may use that as a mechanism to get out of testifying. But
Lori's niece, Melanie, was supposed to testify in Lori's case, and she was a witness for the prosecution. But she, in fact, watched some of the coverage ahead of time and got out of being, basically out of having to testify. She's definitely Lori's little minion, so I completely understand what John Pryor's talking about here, because any witness could just say, oh, I watched the trial, so I don't have to be a witness.
they may use that as a mechanism to get out of testifying, but if that's the case, we can discuss that during the trial if I think that has occurred. But other than that, Judge, I agree with your exclusionary rule, and I think it's fair to invoke that.
Judge, I think as a
of-
general rule, the state does not. I think sometimes a concern comes up that if witnesses are not inclined to testify, they may intentionally review or view some testimony as a mechanism to try to avoid testifying. Only for that reason, I don't know if the court believes that it would be appropriate to do some kind of an admonishment at the outset, in addition to the written order, just advising something along those lines. We don't want to run into that situation for the state or the defense witnesses.
I concur, Judge. That's my only concern, is that the state's aware of my witnesses, and some of those folks may try to do that. And if that's the case, we're going to have an individual hearing. I hate to think that people would do that, but if that happens, the state, that they may have people who may try to do that as well for the defense. So exclusionary rule is fine, Judge, but maybe leave the opportunity to address individual witnesses if we find their behavior may not be entirely pure.
Understood. And it's an interesting concern, but I think it can be resolved on a witness by witness basis if it comes up. The exclusion, of course, is discretionary. If the court finds there's a violation, it's not an automatic sanction or really even governed by any rules. So if I were to determine someone had tried to intentionally avoid testifying, they can still be compelled to testify, brought in under subpoena and required to testify. It would just be a question of whether or not that's influenced their testimony in any way, but certainly does not automatically preclude them being required to testify. And I would likely compel someone to testify if, in fact, I thought they were trying to use that as a shield against being required to testify. So hopefully that doesn't happen, but I would instruct counsel to, of course, advise anyone that you do intend to call, if you have an opportunity to talk to them, that's probably a strategy that would not be effective if they thought it was going to be. All right, so what I'll likely do then is just, so I have it in the file and everyone's aware, we'll get an order issued sometime before trial starts that will provide for the exhibits before trial. They could just go directly to the Ada County Courthouse.
And Judge, could I have some time frame as to when you want that done? I would assume probably the latter part of March.
Just probably really any time before trial, or even as we're starting with the jury selection is going to take a while. So even during the jury selection time, I think we could work on getting exhibits in and submitted into the record.
And I'm aware the court has an order that allows us to disclose all of our exhibits and our witnesses by the 10th of March. And I assume that I can do that by email to your clerk and counsel, and they can do the same. Is that correct, Judge?
Yeah, that will be an acceptable way to comply with that part of the scheduling order. All right, Ms. Blake, then anything further from the state this morning?
No, Your Honor.
All right.
Sorry. No, Judge, that's all. Thank you, Your Honor.
All right, counsel, that'll conclude the pretrial conference then. The court will keep in contact with you in regards to the jury selection process and timing of that. We'll get a proposed schedule out. And for those motions in limine, if you could get those.
Now there's something weird that happens. I'm not sure exactly, but everyone starts laughing. I magnified the volume very high so that maybe we could hear what was happening.
Filed. All right, we're going to go ahead and call it a day then on this pretrial conference. Thanks for your attendance, everyone, and we'll be in recess.
Thank you, Your Honor.
All right.